Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In today's video, we will talk about open justice, a vital principle to the rule of law. We will also look at how it has been called upon recently in relation to the Lucy Letby case. And we will share our personal experience of remotely participating in Lucy Letby's appeal hearing. But before doing so, I wanted to thank you all for your patience during this break, which was admittedly longer than anticipated. Unfortunately, I had to take some time off to deal with some health issues. I'm happy to say that those are almost resolved and we are now back with our weekly chats. Ensure to hit the notification bell below to be notified when our next video is out. That said, let's jump straight into today's chat. Sit back and relax. So what is open justice? As already mentioned, open justice is a fundamental principle which allows the public to understand and scrutinize the criminal justice system, and in return, a way for the criminal justice system to gain public confidence. It is often and traditionally explained by the statement expressed by Lord Chief Justice Hugh Wirt in 1924 in the case of the King versus Sussex Justices ex parte McCarthy, stating that it is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. In practice, open justice is accomplished by allowing the public to observe court proceedings, allowing the media to report court proceedings, and in its broader terms includes allowing public access to court documents, evidence, and judgments. It is a principle that not only is long established, tracing back to before the Magna Carta, but it is also protected by Article 6 of the European Convention of Human Rights, as ratified in the UK by Article 6 of the Human Rights Act 1998, which states that in the determination of his civil rights and obligations, or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. However, we must stress that though fundamental, the principle of open justice is not absolute. Reasons such as national security or child protection are often called upon as limits to this principle. These limitations are scattered in various statutes as well as case law, which renders the whole issue of open justice limitations rather complicated and convoluted. A trend we are now so familiar with anytime we attempt to analyze legal issues in our justice system. In fact, some of these limitations formed the basis of an order made by Mrs. Justice Steyn well before the trial against Lucy Letby started, which banned the publication of information which could identify the babies who form part of the charges against her, their parents, as well as some of the doctors and nurses who worked at the hospital alongside Lucy Letby and who were heard at the trial as witnesses. These restrictions, which were unprecedented outside cases involving national security, were widely commented upon and criticized at the time, and we will not focus on them for the purpose of this video. The principle of open justice has had very little scrutiny and re-examination until 2022, when the Justice Select Committee began an inquiry examining the effect of digitization on the courts, the media, and open justice. The inquiry concluded with the publication of a report titled Court Reporting in the Digital Age, published on the 1st of November 2022. The report contained a series of recommendations in relation to listings, remote observation and broadcasting of hearings, as well as access to court documents and judgments. The government welcomed the report and responded by stating the government remains committed to upholding the principle of open justice. We are confident that the steps we have taken and continue to take strengthen the accessibility and transparency of the justice system. The £1.3 billion HM Court and Tribunal Service Reform Programme aims to create court and tribunal system which is just, proportionate and accessible to everyone. I will link the committee's report and the government's response in the link below. Furthermore, as part of this revolutionary reform, and still on the topic of open justice, on the 30th of April 2024, in her keynote speech, Lady Chief Justice Baroness Carr-on-Waltham-on-the-Hill announced that she established a Transparency and Open Justice Board, which will be chaired by Mr. Justice Nicklin, with the aim to examine and modernise our approach to open justice to ensure that we take proper account of wider societal changes as well as those being affected by the courts. It will set objectives for all courts and tribunals, focusing on timely and effective access in terms of listings, documents, and public hearings. It will engage with the public and interested parties to make sure that these objectives properly reflect what should be delivered by a modern justice system. The board's terms of reference were published on the 29th of April 2024, and again I will link them in the description below. In short, the number one terms of reference is to lead and coordinate the promotion of transparency and open justice across the court tribunals in England and Wales. The board will engage with interested parties to finalise a set of key objectives against which the jurisdiction's current delivery of transparency and open justice can be assessed. Also to identify any obstacles or risks, with the ultimate goal to propose a programme of changes to achieve the identified set of objectives. It is in this context that I wanted to share with you my recent experience with open justice when Barbara and I applied for permission to remotely attend Lucy Letby's appeal. But before doing so, if you're finding this video useful, ensure to hit the like button below, and if you have not done so already, subscribe to our channel to help us in our mission to humanise the criminal justice system. Back to Lucy Letby's appeal. Due to my health problems, I was unable to travel to London to attend Lucy Letby's appeal in person. So I was delighted to hear that an order had been made on the 11th of April 2024, allowing remote access to the hearing. By way of background and briefly, remote observation of public hearings was first allowed by temporary provisions enacted by the Coronavirus Act 2020. The temporary provisions were subsequently repealed and replaced by a new and permanent regime. The basis of the new provisions can be found in Section 85A of the Courts Act 2003, which was introduced by Section 198 of the Police, Crime, Sentencing and Courts Act 2022. In short, Section 85A states that the court may direct that images or sounds of the proceedings are to be transmitted electronically for the purpose of enabling persons not taking part in the proceedings to watch or listen to the proceedings. The regime is implemented by the Remote Observation and Recording Court and Tribunals Regulation 2022, which came into force on the 20th of June 2022. Also, further directions can be found in the practice guidance on remote observation of hearings in the judiciary website. Again, links are provided in the description below. Though not currently practicing as a solicitor, my solicitor's skills came handy when I wrote to the court to seek permission to attend. I knew too well that if I were to be given permission, I had to make sure not to leave any required detail out. Well familiar with court's time pressures as a former prosecutor, I knew that the judge would have probably been asked to look at all the requests just before the hearing, and most likely with very little time at her disposal. So I tried to make her job easier by including all the details in the same order as requested by the court order. And so I did. I emailed following the order to the letter. However, sometimes later I received an email from the court clerk asking me to fill in a form instead. This form, which was not mentioned in the court order, was not fit for purpose. So it did not have sufficient space in which to include certain information explicitly requested by the court order, such as, for example, whether I will be in the jurisdiction as opposed to abroad whilst attending the hearing, or including the express and important declaration not to make a recording, capture images, and or broadcast any part of the proceedings, or share the link with anyone else, etc. I filled in the form. As you can see, the form has just really specific requested information, and relied on my detailed email to compensate for any omissions in the form. These then led to a chain of emails back and forth between the clerk and I, with further requests each time asking for more and more details, which, though annoying, as I had already covered all in my comprehensive original email, I duly complied with. On the day of the hearing, an hour prior to the starting of the proceedings, I still had not received either the remote link to participate to the hearing or an email confirming reason for refusing permission. So I telephoned and inquired with the clerk, who could not find my request, nor was I on the list of those whose permission had already been granted. It was by now 10:24 and the hearing was to start at 10:30. It was then that I sent the following mentioned in a minute from the practice guidance on remote observations of hearings, in a final attempt to convince the clerk that there could not possibly be a reason for not having been granted access, and if there was, I wanted to have that in writing. The passage states that decision makers must give due weight to the importance of open justice. This is a mandatory consideration. Open justice serves the key functions of exposing the judicial process to public scrutiny, improving public understanding of the process, and enhancing public confidence in its integrity. Remote observation can promote all of those purposes. Access for reporters, legal commentators, and academics is likely to do so. Judicial office holders may take as a starting point that remote access for other observers is desirable if they will be entitled in principle to have access to a courtroom in which the hearing was taking place, and giving them remote access is both operationally feasible and compatible with the interests of Justice. In reply, I finally received written permission and the link to access the hearing. However, it was now 11:15 and I had now missed the opening of the hearing, which undoubtedly gave me some disadvantage in understanding the basis for the appeal. Barbara, however, was not so lucky. You see, she did not check her email and missed the further request to fill in the form, so she missed the hearing altogether. This shows how much is left to be desired and how much work is still needs to be done to address the principle of open justice. If you attempted to attend the appeal of Lucy Letby and had a similar experience, do let us know in the comments below, or for that matter, any other hearing remotely. It will be interesting to share experience, and perhaps we could feed this to the newly created Transparency and Open Justice Board once engagement with the public is sought. Having attended the appeal hearing, however, I'm unable to pass on any information, as yet again reporting restrictions were placed by the Court of Appeal in light of the retrial due to take place on the 10th of June 2024 in relation to one of the counts upon which the jury failed to reach a verdict. Therefore, I can only report that no decision was reached on where Letby will be given permission to appeal, as the court reserved judgment to a later date. The topic of open justice also featured during a session of justice questions in the House of Commons on the 14th of May 2024. You probably have seen from news that Sir David Davis MP, addressing Justice Secretary Alex Chalk, questioned why an article featured in the New Yorker, which he said raised enormous concerns about both the logic and competence of the statistical evidence that was a central part of the Lucy Letby trial, was blocked for publication in the UK. Let's hear what happened.
So David Davis.
Yesterday, the New Yorker magazine published a 13,000-word inquiry into the Lucy Letby trial, which raised enormous concerns about both the logic and competence of the statistical evidence that was a central part of that trial. That article was blocked from publication on the UK internet, I understand, because of a court order. Now, I'm sure that court order was well intended, but it seems to me in defiance of open justice. Would the Lord Chancellor look into this matter and report back to the House?
Well, I'm grateful to him for raising it. Court orders must be obeyed, and court orders can be displaced by someone applying to the court for them to be removed. So that will need to take place in the normal course of events. But I would just simply make the point on the Lucy Letby case that juries' verdicts must be respected. If there are grounds for an appeal, that should take place in the normal way.
And what do you think? Is the court order in defiance of open justice? Let us know in the comments below. In the meantime, on the 16th of May 2024, in a preliminary hearing for the Thirlwall inquiry, which is set to investigate the events surrounding the Lucy Letby case and the wider NHS culture and management, it was announced that the substantive hearings are due to start on the 10th of September 2024 and will take place at the inquiry's venue in Liverpool Town Hall. Also, the chair, Lady Justice Thirlwall, heard submissions from lawyers representing families, the Countess of Chester Hospital and the media on whether the hearing should be publicly broadcast. Lady Justice Thirlwall will announce her decision in due course. This concludes our session today. I hope you have enjoyed it, and if so, do like and subscribe. Join us again next week when we will share the details of our brief encounter with Mr. Markinson and a new campaign launched by Appeal, a UK charity and law firm dedicated to fighting miscarriages of justice in relation to majority verdicts. a topic that we have covered in a series of 3 videos, which you can find in our playlist at the round table. Until then, remember that when a word is spoken aloud, it summons power and meaning, carrying a degree of responsibility. Be mindful of where your words may land and who they might affect. We look forward to usher you as we sit and rise in this unique trial.